Mr. Mourre.
Good morning, everyone. First of all, I'd like to thank the University of São Paulo and Mourre for inviting me to this fascinating conference today. And I've been given the daunting task of, in 15 minutes, say some words about the future of international arbitration, which of course cannot be done in 15 minutes. But what I can do in such a short time is some maybe disordinate reflections. And I think that the starting point for this reflection should be that international arbitration has at the same time been one of the propelling factors of the movement of globalization of the economy that we have seen in the past 30 years. And at the same time, it is a byproduct of that movement of globalization. The cornerstone of that global system of justice is, as Marike said at the outset, the New York Convention, the most successful international convention ever, probably setting principles of recognition of arbitral agreements and limited review of arbitral awards. And this is really the starting point of modern arbitration as we know it today. And in this process of globalization, at the same time structuring of arbitration as a global system of justice, arbitration, of course, has transformed itself. It has become an autonomous and, in a very large measure, detached from states' system of justice. It has become what Emmanuel Gaillard and some scholars call an ordre juridique arbitral, an arbitral legal order. And this global system of justice is composed essentially, and that is the backbone of it, of a net of arbitral institutions, thousands of arbitral institutions in all continents, cutting across all industries, now resolving the most part of international disputes, both commercial and involving investments, for large and for smaller amounts. This system rests on an arbitral community, which Professor Gabriel Kaufmann-Kohler once called the epistemic arbitral community, also a global community of practitioners and academics from all countries, all sharing the same ideals, the same vision, and this epistemic community has propelled the elaboration of something that is fundamental for arbitration, and that is transnational soft law rules for arbitration, in particular as far as procedure is concerned. Organizations such as the IBA and ICA have been instrumental into that. So it's fair to say that without arbitration, investments would be deterred. The resolution of disputes in state courts would take much longer, thereby affecting the ability of businesses to protect their commercial ventures and business relationship. However, as a global system of justice, it is an imperfect system of justice. First, because it lacks transparency. Second, because it is not fully autonomous from states. There is still state intervention in arbitration. Awards are subject to review by states, and at the end of the day, the autonomous nature of arbitration rests on pro-arbitration favorable statutes that are precisely adopted by states. If there were not such a pro-arbitration policy on the part of states, there would be no arbitration as an autonomous system of justice. Now, this imperfect global system is also a system that is now challenged as it has never been challenged before. First, you all know this, of course, arbitration is now facing a historical legitimacy challenge, in particular in investor-state disputes. And this has culminated some weeks ago, and Professor Battista just referred to that decision with a European Court of Justice decision in the case of Achmea versus the Republic of Slovakia, where the European Court essentially said that investment treaties entered into between member states are incompatible with EU law because they remove from the union's legal system the control of the proper application of EU law. And we're not talking about the policy, we're talking about EU law as a system as a legal system. Now, in that decision, the European Court of Justice has established a distinction between investment and commercial arbitration, but when you look at the decision, it is far from clear that it will not have the potential of putting into question principles of limited review of awards that have been applied in Europe since the Eco-Swiss decision at the end of the last century. This is, of course, not a topic that I can address today. It is a very complex question, but I think that there is some cause of concern on where we are going, not only for investor-state dispute, but also for international commercial arbitration. And more generally, it would be a great mistake on our part to believe that the backlash and the challenges that are at the moment being raised to investor-state arbitration will be limited to investor-state arbitration. They have the potential to spill over commercial arbitration. And the system of arbitration also faces other challenges in terms of its ability to self-regulate, in particular as far as ethical rules are concerned, and also regarding diversity and transparency. And I would submit in the very limited time that I have that the arbitration community needs to address the three fundamental questions that are legitimacy, predictability, and efficiency of arbitration. And in order to tackle these three challenges, I would submit that arbitration needs to progress in 6 different directions, which I will very shortly mention. First, we need to establish a transnational procedural framework for international arbitration. It is to a large extent already in place with rules such as the IBA rules on evidence and the IBA guidelines on conflicts, but we still need to reach universal acceptance of transnational ethical rules for counsel, for example. The question of arbitrators' disclosures is also fundamental from a systemic perspective, as much as that of the ethical rules that should apply to arbitral institutions. In sum, the establishment through soft law of a comprehensive, predictable, and universal system of rules is key to the future of arbitration as an autonomous system of justice. Second, we need to increase the transparency of the system of arbitration. Transparency is relevant in essentially 2 respects. On the one hand, it increases the confidence of the system, on the part of the general public. One of the arguments that has been most frequently used against investment arbitration is its alleged secrecy. Unknown, unelected arbitrators deciding the fate of people behind closed doors. And the Mauritius Convention that has established standards of transparency for ISDS has done a lot of good, but transparency is also very relevant to international commercial arbitration and for the work of arbitral institutions in the future. I think that the idea that international commercial arbitration is confidential per se, that those cases should be resolved in secrecy is something that is now out of the window. In 10 years from now, we already see publication of awards, even if they're supposed to be confidential. No later than yesterday, I was in an ICC conference, by the way, where one of the speakers at some point mentioned the case, which I know for being part of it, and that is confidential, and how he got the information, I don't know, but I was surprised. So this is, of course, a fundamental question. On the other hand, the publication of awards, still to talk about transparency, on a much more systematic basis is the only way to develop more consistency and predictability, as well as to develop a system of precedent in commercial arbitration, in particular in disputes related to certain industry where recurrent questions are always submitted to tribunals. Without more reliability on past cases, which can only be achieved through transparency, arbitration will not be truly able to maintain itself as an international legal order. Third, we need to dramatically increase diversity in arbitration, and here the situation is not good. Numbers say that, for example, in the ICC, which is the system I know, of course, more than 70% of the population of arbitrators confirmed or appointed by the court originate from Western Europe or North America. This is, of course, not reflective of the reality of arbitration today. 15% only of our arbitrators are women. And of course, this is not good either. We need to do more efforts on this. And it is, I think, incumbent on arbitral institutions such as the ICC to do this effort to promote a new generation of arbitrators and a more diverse generation of arbitrators. Fourth, we need to tackle in a much more meaningful way the question of the time and cost of arbitration, the efficiency of arbitration. I will not discuss this today because it is a huge topic. This can be done, and again, institutions have a leading role to play in this respect, to the introduction of novel systems such as the expedited rules for claims of limited value, as the ICC has just done in its 2017 revised rules, but also by the development of best practices and techniques such as bifurcation, such as summary dispositions of manifestly meritorious claims, etc., etc. Fifth, we need to restore the confidence of states and the general public in ISDS. We need ISDS. It would be a fundamental error to believe that international commerce and the international system of cross-border investment can live without an efficient and a system of dispute resolution for these investment claims. But simply to say that the criticism against the system, the criticism that we see today, is misplaced and ideologically biased is clearly not enough. There needs to be a meaningful and effective answer other than patronizing and at times somewhat arrogant dismissal of the criticism. There needs to be a legitimate, a meaningful answer to the legitimate concerns that are expressed on questions such as conflicts of interest, bias, forum shopping, multiple actions based on the same claim, inconsistent decisions, excessive discretion of arbitrators in interpreting loose concepts included in poorly drafted bids, speculative and often inflated assessment of damages, etc., etc. What this answer is not for me to discuss today. Again, I have no time, but it is a question that we need to address seriously and not only by saying that, as we say in France, tout va bien, Madame la Marquise, ou tout est bien dans le meilleur des mondes. This is not the right answer to give to these serious questions. And finally, and with this I will close, arbitration, of course, needs to fully adapt to the digital revolution that is coming and which disruptive potential has not yet been fully revealed. This is the topic of your conference today, of course. Blockchain, I know very little about blockchain. I know something, but very little, so I'm looking forward to listening and learning. But if you look at the future, for sure, questions such as virtual hearings with no longer the cost and delays that are caused by physical hearings is something that is pretty much on the agenda today. Whether tomorrow electronic techniques of predictive justice, for example, will allow to dispense with blood and flesh physical arbitrators is another question, which I will leave, I hope not, but I will leave this for another discussion. Thank you very much.